Good morning, good afternoon, and good evening. Welcome everyone to this week's Law as Science event. I'm Patrick Chung-Jia Huang, a JSD student at the University of Chicago Law School, and I will be the moderator for this session. Before introducing today's speaker, let me briefly introduce the Law as Science project. Law as Science is an academic initiative coordinated by a group of JSD students who share the same belief in legal methodologies, often understood as a discipline distinct from hard sciences, traditionally consisting of doctrinal analysis and normative questions. Through this series of interdisciplinary talks, we aim to show that legal research can be improved and benefit from scientific methodologies that provide systematic ways to approach questions and deliver falsifiable claims. If you want to learn more about the Law as Science project, please visit our website and join our email list. Also, I want to introduce our coordinators, Simon Sun, JSD students from Indiana University Maurer School of Law and a co-founder of this initiative, and Daniel Hefke, a JSD student from Cornell Law School. And we also have Vanessa Villanueva, who is now having her graduation ceremony. And also we have representatives from various law schools, Kai-Ping Zhang from UPenn, Sebastian Rego Troncoso from Georgetown, and Sudhi Shah from Columbia. Okay. And let me introduce today's speaker, Professor Yun-chien Chang. Professor Yun-chien Chang is the Jake G. Clarke Professor in East Asian Law and Director of the Clarke Program in East Asian Law and Cultures. His current academic interests focus on economic, empirical, and comparative analysis of private law, particularly property law, as well as empirical studies of the judicial system. He's currently co-editor of International Review of Law and Economics and an associate reporter on American Law Institute's Restatement of the Law for Property. Professor Chang received his JSD and LLM degree from New York University School of Law, where he was also Lehman Milbank Law and Economics Fellow and Research Associate at the Furman Center for Real Estate and Urban Policy. In today's session, he will spend 25 minutes talking about comparative law methodologies he used in his previous works, with a particular focus on his forthcoming book, then leaves 25 minutes for questions and discussions. Professor Chang, the floor is yours now.
Thank you, Patrick. Patrick is my former RA and current co-author. I'm delighted to have this opportunity to talk with you, especially because I am a former JSD student. I went through this process being a minority in the law school. People said, you mean JD, not JSD. Now we are actually JSD. And when I was a JSD student at NYU, we started a methodology speaker series, but by then there was no Zoom and we only have NYU professors come talk to us. So now you have this online platform is really great that you can hear from a lot of people from around the US and maybe beyond the US. So there was some, I guess, slight misunderstanding because I've done so much work on comparative law. So I was planning to talk about my book, but then I see your event description saying something like machine learning. So I prepared slides for other dimension. But then anyway, because my comparative law work focused so much on my property data set and other comparative data set with a machine learning method. So in 25 minutes, what can I do? I can only give you some overview of what I'm doing right now. So usually we start this kind of talk as talking about big data. Many of you have heard of it. Maybe some of you are using it, but big data are defined, I think, kind of in a slightly surprising way for me. But it seems that people, at least in the privacy law arena, have defined big data essentially as both a technology or algorithm and vast quantities of data. So big data literally only means vast quantity of data, but when it's capitalized, big data, it also means, you could say, machine learning or deep learning. I'll give you Julie Cohen, Leo Strahilovic, and also Frank Pasquale, who's moving to Cornell, also define big data as both a technological trend and flood of data. So you could use this useful 2x2 matrix to see what people said about big data is when you have a large N, meaning you have a large data set, super large data set, and you're using artificial intelligence to process the big data. What we learned in high school, traditional empirical legal studies, something like standard deviation, means, median, these are using human intelligence when an N is small. You could, and we have in our math class a hand calculated mean, and these are kind of the polar opposite of big data. And then some of you may have statistical training in the more advanced classes, so then you run regressions. This is a traditional empirical legal studies. When the N is manageable, like back in the day, if I have 500, 1,000 observation, I'll be very happy. Now, if you have 10K, 100K observation, this is still like small as compared to what Facebook, Google, and other tech giant has in their big data. So we just call it a small N, but we use artificial intelligence. So if you have learned how to run regressions, congratulations, you have already in AI, because computer scientists classify regression as one type of machine learning. We'll talk more about that in a few minutes. And then when you have a large N data, but use human intelligence again, then you have what I call the enhanced empirical legal studies. An example would be a paper from China that I've read, which used 30 million criminal cases in China and have one goal in mind, calculating the number of representative cases, meaning calculate the number of cases in which the criminal defendants are represented by attorneys. Simple descriptive statistics, but super large N. So today I'm going to talk about machine learning. We can place it in the small N category here because comparative law data by its very nature will have at most 200, 300 N. The more country, the merrier, but even if we have many, many more countries to come, we will still have a small N. Okay, so under the head of AI, there's machine learning and deep learning. So much of the AI outside of machine learning are really old news. I don't think any of you would want to use it or have been using it. Well, machine learning is, well, still respectable, but many people are moving to deep learning, especially when they have millions of documents to crunch. So today I'm talking about machine learning outside of deep learning. I'm not yet stepping into deep learning yet, but many of the projects that are going would call for deep learning. And this is just an evolutionary plot saying that machine learning has been with us for a long time. If you count regression, then it goes back 100 years. Okay, so machine learning basically is to use an automatic algorithm to find patterns with complex data. And the goal of machine learning is to understand the structure of the data. And today, many of my driving examples would be to understand how to classify countries into legal families. And this might be a more useful plot where you can see machine learning can be divided into supervised learning, unsupervised learning, and reinforcement learning. Well, if you have played certain RPG games, then it uses reinforcement learning, but I'm not a gamer, so I'm not talking about reinforcement learning today. Well, supervised learning and unsupervised learning, the main difference is whether you label an outcome. Okay, so imagine a medical context. So we've been to doctors, and doctor will look at the X-ray result and trying to find pattern from the X-ray to see whether we are fully healthy or there's something going on. But it depends on the doctor's experience. So in a supervised machine learning algorithm, a applicable to a medical context, there will be hundreds of thousands of X-ray results read by experts, and they would label the X-ray as no problem or some problem. And then the machine learning algorithm, in terms of supervised learning, will learn the label, no problem, some problem, and then learn what the image could be kind of analyzed to find patterns for problems. So then when there's a new X-ray coming, we don't need a human medical doctors to make the judgment. The supervised learning algorithm, after learning hundreds of thousands of X-rays, could provide a judgment. So that's kind of supervised learning. Well, unsupervised learning, there will be no human labeling. You just give the algorithm data or just give them text, and they will give you some classification. We'll see more example about that. So today, I'm not going to talk about regression, many of you are familiar with, but rather I'll talk about classifications under supervised learning, and also dimension reduction and clustering under unsupervised learning. And before we do that, let's look at some human intelligence research. So any of you who have kind of some interest in comparative law must have heard of it, or if not read, Zweigert and Kurt's Introduction to Comparative Law, originally in German and translated in English. They classify legal families into like the French system, Portugal system, Spanish system, English system, socialist system, East Asian system. But the problem with human intelligence, and in particular the Zweigert and Kurt's book, is that they never give very clear-cut criteria for classifying countries into families. They give some hints, like the colonial history, the ideologies, and all that. But the problem is, like in the case of socialists and socialists in East Asia, you could say, well, there is no overlap. And the book was never clear, telling us, so when two different criteria lead to different classification, how do they ever come to like one single conclusions? So these human intelligence are not replicable. So there are some whites, country colored in white in Africa, and we don't know how to classify them into French, Portugal, or Spanish or English socialist legal system based on their criteria, because the criteria was not clear. So, but that's kind of the state of the art before there are really detailed data about property system and a trust system and other aspects of the legal system. And even with those kind of systems, you could still use a world map. Like LLSV, they kind of using an encyclopedia of law in the 1990s, late 1990s, classified legal origin into 4 types, which spawned, like that article alone in 1998, have more than 20,000 citations. I would say mostly negative, but citations are citations. And then a lot of follow-up studies using legal origin classification. This is slightly different from what lawyers would use as legal families, but there's a significant overlap. So, so the idea I got then 10 years ago was to really look at it empirically. So at the time, there was 2-3 groups of constitutional law scholars doing coding of constitutional law. And one of them is Tom Ginsburg and his collaborators, and Patrick, Tom, and I and others are doing a machine learning human rights project. And we'll have a presentation very soon in Cornell. So maybe you guys, some of you guys at Cornell could come in early June to listen to the talk. So, but let me focus on my property data alone. So with property data, I could hold, for example, good faith purchase doctrine in property law, and then say, how can we classify the worlds into several groups based on the substance of their good faith purchase doctrine? This is still human nature. I am using my lawyer training, comparative law training, to read civil codes, read cases, read monograph, and trying to tease out which jurisdiction have which rule, and then just classify them. We could do that for other dimensional property law like transfer ownership, adverse possession, and then we could also, like a more heavy lifting human intelligence, will be calculate correlation coefficient of a country's property law across 200 dimension with every other country's. Since my property data would have the same set of variable on the same substance dimension of property law, I could do correlation of coefficient with, for example, here, Taiwan's property law. You can see the darker the color, the more similar it is to that country, like Japan, South Korea, not surprising, has very similar property law to Taiwan. And in the case of China, the former USSR republics, like the Russian speaking republic, and also the US, are in the top 25 percentiles in terms of similarity with property law in China. Okay, and we could do that with the English law. And then there's other synergies when you could combine two data sets. So Anu Bradford at Columbia and Adam Children at Chicago built antitrust data sets. So we team up together to see whether the legal origins in LLSV or in others classification would help us predict legal substance. That is, the LLSV study, which is very influential, which became the policy foundation for the IMF and World Bank, because LLSV's finding was that common law is better than civil law in terms of facilitating legal economic development. And the kind of the idea or the logic was because legal origin, in particular English legal origin, correlate with or predict current legal system rule. Like they say, common law has better investor protection, better corporate law than civil law. So that leads to higher, faster economic growth. And then our idea is, so for the legal origin idea to work, legal origin, which was determined in the 18th and 19th century, should be able to predict the variation across some legal doctrines. And then the different legal doctrines would facilitate or contribute to economic development. But if we find that legal substance was not kind of following legal origin lines, then the whole logic of LSV would crumble. So here you see two plots. So the takeaway here is just basically, you see in competition law and antitrust law, the distribution of country with shared legal origin and the distribution of country with different legal origins are basically entirely overlapped. So that means whether a pair of country has the same legal origin or not does not tell us anything about whether they will have similar antitrust law. So I mean, legal origin is not helpful in predicting legal substance. While on the left, you see property law, the distribution in pink, which shows shared legal origins, is to the right of the distribution of different legal origin. That means knowing whether a pair of country have the shared legal origin, for example, both in German legal origin or both in French legal origin, would tell us something about the similarity. That is, legal origins still, like with same legal origins, still correlate with a higher correlation coefficient of property law. Okay, so if you want to support LSV, you could say maybe antitrust law or competition law is not important for economic development. Property law is like the most important thing. Like as property scholar, I'll probably like this claim, but there are like more research needed, like you can see from contract law or from other law, to see whether legal origin predicts legal substance. In fact, Mila Versteeg of Virginia, Adam Chilton, Nuala Garopal, George Mason, and I, we have a working paper using all the existing comparative law data to see whether a legal origin would predict legal substance across like in 8 or 9 fields. So stay tuned. Okay, so far I'm telling you about small n and human intelligence, and below I'm going to tell something about small n and artificial intelligence. I'll try to finish in 10 minutes so that you can ask questions. There will be a lot going on, but I will just be brief, but because there will be working papers and books that you can read. So these are my property data source. Basically, all the jurisdiction that have English sources. I'm trying to code all of them. For the US, I code New York, California, and LA because it's a pain in the neck to pin down 50 states with similar legal rules. Okay, so you can already find this paper with Han Wei, a statistician, Patrick here, and me in a Cambridge Handbook of Comparative Law. It's already on SSRN. So there are a bunch of machine learning methods that we can use on the property data we have. So recall, there are 156 jurisdictions in my data set. And each jurisdiction, I coded 270 dimensions of property law, okay? So there will be like good faith purchase, adverse possession, transfer of ownership rules, and all that. So let's look at dimension reduction. This is very useful if you have comparative law data or any data that just you just coded and you wanted to know like whether there's any pattern in it. So dimension reduction, you can start with like you have some 3-dimension things, and but when you try to submit to a journal, the editor tells you we cannot publish 3-dimensional plots. So try to like simplify. You can simplify into a 2-dimensional thing, or you could like further simplify it to be one line, and then all your observation will be line up in that line to see whether to what extent they are similar. But usually like 2-dimensional is fine. So let me skip principal component. This is like so very basic. Like Tisney is cool. It's a T distribution method. You don't have to know the technicality. Just it's basically knowing that there are 270 dimensions in my property data set. So unless you have some like superhuman skill, you cannot just look at a spreadsheet and immediately know which country is closer to which country. Okay, but Tisney does the work for you. It reduces dimension from 270 to 2 dimensions, and then put every country jurisdiction on this plot. So you can see, you see France and a bunch of French-speaking countries here. You see Japan, Indonesia, and these are like Spain and then South American country here, Taiwan, Korea, Germany, China, Mongolia. So this is like, it tells you the story of which country is more like which country and more distant from other countries. Like you could say Turkey is here is very different from France, and take into account the fact that Turkey was part of the Ottoman Empire, and Ottoman Empire have voluntarily transplanted French civil code. This is an amazing result. Other than that, you could also use UMAP. Okay, so Tisney has a downside that it will not create the same plot every time. So even if you have the same data, same code, you run it today and you run it tomorrow, they're slightly different. For journal publication purposes, it's kind of frustrating, but UMAP will be stable. You have the UMAP code in R, the statistical software. You run it today, you run it tomorrow, it'll be exactly the same. So this is like the same exercise. Reduce dimension from 270 to 2 dimensions, and like looks different from the Tisney distribution. But don't ask what is in the X and Y axis because they are meaningless. These are non-parametric transformation of information. At least in UMAP, it's a non-parametric transformation. So the metrics are meaningless. Only the relative distance and the absolute difference in terms of UMAP would matter. And this UMAP just shows you have to tune the parameters. There are 2 things that you can tune in UMAP, and then depend on which parameter value you set, they will look very differently. On the lower left, lower right, sorry, it will kind of like congregate together, while in the middle, you kind of having some pattern. Okay, and this is a part of the ongoing project with constitutional law data by Tom Ginsberg. So here we do something different. We don't want to allow the algorithm to create two dimensions by its own. So rather we said, give me separation of power on the x-axis, and then give me protection of human rights in y-axis. But of course, Patrick would have to designate or tell the algorithm which variables are separation of power, which variables are protection of human rights, but then it would just reduce dimension into one line in terms of separation of power, into one line in terms of human rights, and then we have this graph showing constitutional law around the world in this two-dimensional plot. Okay, you can see while Taiwan, Japan, China, some East Asian countries are quite far apart on the plot. Okay, that was dimension reduction. Now we talked a bit about clustering. And first, clustering is an unsupervised learning. So as I said, you spend, like me, maybe 10 years coding 156 jurisdictions and 270 dimensions of property law. So you basically have a 156 times 270 spreadsheet. Okay, you look at it, you're trying to see patterns, but you don't have superpowers, so you don't know. And that's when you want to have unsupervised learning. Unsupervised learning, you don't have to label anything, just give the algorithm your data. It could be continuous, it could be binary like mine, and then you will give you, for example, a dendrogram. Okay, a dendrogram is a legal family tree, you can say, that puts countries similar to one another close together in the branch, and then puts countries that are very different on the different trunks, so to speak. So in my 2021 paper on JLA, we find that the common law was actually much closer to the Russian and former USSR Republic law and Chinese law than other countries. So the prior literature that coded both the Nordic countries, China, Mongolia, and former USSR Republic as civil law wasn't consistent with the data I have. I'm not saying that Russia has common law. I was just saying, like, in terms of the substance of property doctrines, these countries are much similar to one another than to German and French civil law. So this is just a graphic presentation of what the family looks like. Okay, finally, some unsupervised machine learning about K modes. So basically, you can think of K is the number of group. Say you don't like common versus civil law, which is K equals two groups. You don't like LSV's 4 categories. That was French, German, Nordic civil law versus common law. You like six groups. You like 10 groups. So no matter how many groups you like, you can use K modes. Like here, I show you can divide countries into 2, 3, or 4 groups. I didn't put the label here because it would be difficult to see, but on your in your data set, the algorithm could tell you which country belongs to the first group and when K equals 2, or belong to the second group when K equals 2, and so on and so forth. So there are, like, the takeaway point for you is there are more than one, and oftentimes many different types of unsupervised machine learning. So you could use the method that makes most sense for your data sets. And if you don't know what these algorithm means, you could read our book chapter. We tried very hard to make this accessible to traditional lawyers who have no training in statistics and machine learning. So finally, a few minutes on a classification, a supervised learning method. Like I said, recall the X-ray example. You need to have labeled data to do supervised learning. The label could be, this country is civil law or German civil law, that country is French civil law, and that country is common law. So supervised learning then like kind of eat the data given the label and then find a way to say, okay, there is a way. Maybe some variables are the critical, most important variable in distinguishing between being a French civil law or German civil law versus common law. And then where's a new country coming up? Like I didn't call Saudi Arabia. I didn't call Iceland. If someone used my code book to call these countries, they could just throw Iceland and Saudi Arabia in the algorithm and then use the same pattern. The algorithm could tell you, following the LLSV classification, Iceland would belongs to which group, Saudi Arabia would belongs to which group. So like KNN is meaning K nearest neighbor. This is basically kind of a realization of this in English idiom, a man is known by the company it keeps. So here in comparative law, you could say a country is known by the neighbors it keeps. So the only thing you need to determine is how many neighbors should determine your classification. So if KNN equals 1, like the plot on the left, that means your single nearest neighbor will determine your classification. For example, if we throw Iceland into the picture, and it seems that Denmark is closest to Iceland, and Denmark will classify as Nordic, then Denmark will be Iceland will be classified as Nordic. But if on the right plot, for example, you want the 5 nearest neighbor, you want a majority vote, then when Iceland is thrown into the picture, maybe the nearest neighbor is Denmark, Norway, Germany, US, and Brazil. Then the nearest, like the 3 nearest neighbor, which have the majority, will determine how Iceland will be classified. And in the chapter, we discuss how to determine your K. Basically, you could say it's the square root of the number of observation. That's kind of a rule of thumb. And the most important thing is to use confusion matrix like this when you have training data set and then you predict groupings, because KNN is a supervised learning. So you already know the answers for the observation in your data set. So you use maybe half or 40% of your observation as training an algorithm, and then use that algorithm to predict the observation not in your training data set and produce a confusion matrix. If all the countries are on the diagonal line, meaning the algorithm learns pretty well and can predict countries that you already know the answer, then that means you're ready to send it to the uncharted territories to see whether this algorithm helps you determine classification of legal families to other countries. So that's kind of a very quick, I realize, a very quick review of comparative property law in machine learning method. My book, which will be published this month, also used this method to study property law in further detail. But I gather it's best that I leave enough time for Q&A than for me to mumbling on. So Patrick, I give the mic back to you.
All right, so anyone have questions, please raise your hand to be queued. I personally have one. Okay, sure. Daniel, please go ahead. Yeah.
No, go first. I can go after.
All right. My question is, it seems like in your property set, property law data set, every variable is treated equal weighted. But I wonder whether it is it does reflect the true similarity between jurisdictions. Let's say that Sudan and Mongolia have two property law data, which shows agreement with nearly all variables, but only different disagree with their riparian laws. But as we know that in these two countries, there are nearly no rivers. Does that really show that these two jurisdictions share different property law because of rarely used legal doctrines or some rare use legal variables?
Okay, I actually get this question all the time. And the funny experience is because I've been working on it for 10 years and I've given talks, Europe, to US, Canada, and throughout Asia. And people would read the paper and said, for example, in Germany, they would say, like, you coded a minor doctrine and these should not be in your data set. And in France, people pointed at another doctrine that this is not an important doctrine, you should have taken this into account. But the funny thing is, people in different countries think different doctrines. Think of different doctrines as minor or trivial. So it's very hard for us, or for me as a property scholar, to give a proper weight, because that will introduce my bias. So especially when you're using unsupervised learning, maybe part of the defense is, no matter how minor the human intelligence intervention is, it will introduce bias. Like before us, or before the recent surge of quantitative empirical comparative law, people just use LLSV's classification because it's hard to challenge that based on no data at all. So now with data, so like one response is weighting variables will introduce human bias. Second is, so far there is no good algorithm that could easily incorporate weighting. But that said, inevitably, methods like this include weighting. For example, I coded 270 dimension. I'm sure if you are like kind of property scholars, you could say, why haven't you coded X and Y? Like I didn't code riparian law because mostly riparian laws are outside of civil codes. But you can point to riparian law. You can say, well, intellectual property is property. Why didn't you code intellectual property? You can say zoning is part of property. Why didn't you code zoning? So by making that decision not to include certain variables, I already assigned them a weight of 0. That's like point number one. And then point number two is when I decided to use 5 variables to code adverse possession and 10 variables to code good faith purchase, for example. And I already give good faith purchase a higher weight than adverse possession. I have consciously tried to not give this when I determine how many variables I use, but that's kind of also introducing some weighting, and the exact weight are also very difficult to compute, because especially in unsupervised learning, if there is one doctrine that have no variation, then it was given a weight of 0 from the algorithm. For example, in the core 129 jurisdiction I use in my book, all of them has condominium. So condominium becomes useless for distinguishing countries into common or civil law or into my legal family, because everyone has it. So even if I, in the pre-algorithm state, thinks, oh, condominium is very important, I give it like double weights, but because there is no variation, the weight I give will be omitted anyway by the algorithm. So this is a very good question. And I think the only sensible solution would be to kind of make my assumption clear and leave it to the readers to see whether the results make sense or the method makes sense. But so far, I think that's the best one can do.
Daniel?
Yeah, so first of all, thank you so much for giving this talk. It was really fascinating. I learned a lot. My question is much more broadly about the methodology. So at the beginning of your talk, you mentioned Zweigert and Kurtz, and I'm doing qualitative comparison, and I'm very much influenced, by the pushback to Zweigert-Kurtz functionalism. I mean, since the 1980s, really. And I mean, there are several pushbacks, but the main one is aimed at their credo that law must be stripped from its cultural undertones. And the critics insist that, to understand and compare systems, we must do the exact opposite. We must broaden our view and study legal culture. And that means not committing to a positivistic understanding of law, but instead study additional sources than just legal texts, basically. Now, and now it seems to me that machine learning comparison is undoubtedly useful for taking the Zweigert-Kurtz route. which means committing to a positivist understanding of comparative law. And my question really is, you think that's true, that machine learning comparisons linked to the positivistic approach, or would you say it's first and foremost a methodology, a tool, and is equally open to more culturalist approaches to comparison?
Okay, very good question. I would think machine learning tool is definitely a more accurate and open and replicable approach to the functionalist roots that Zweigert and Kerr's like champion. Like, no matter in econ or in law, if you want to classify countries into legal families, I think nowadays you could not avoid using data because there are 8, 9 legal fields that have data already. You cannot just omit them and then make kind of empty-based claim about legal families. And your point about legal cultures. So in my book, this book, I have used, again, a quantitative approach using data from 2 social psychologists, Hofstede et al. And Schwartz et al. They've measured either 6 or 7 dimensional cultural aspect of dozens of jurisdictions. So in the book, I try to use like the masculinity, the deference to authority, these kind of cultural dimension to see whether that would explain the finders keepers rule or explain concurrent ownership voting rules. And the quick takeaway is none of the cultural aspect help explain the variation I see from comparative property law. There may be several reasons. Maybe the cultural dimension measure wasn't important, wasn't accurate, or because in comparative property law, there is so much influence by legal transplant that German rule was carried to China, Taiwan, Japan, and South Korea, despite Germans and East Asians have very different cultural attitude toward law. So you could say that's not surprising that the quantitative measure of cultures wasn't kind of sufficiently able to explain legal variation. But then I'm sure the follow-up question would be, well, what about the law in action? Like there are many countries that have, for example, finders keepers law, different finders keepers law. And some countries have criminal punishment for finders who kind of misappropriate the matters. But people may ask, would it be culturally relevant if in certain countries, prosecutors would say, like, this is none of our business. Like, prosecutors shouldn't chase after misappropriating finders. We have better things to do. Well, in other countries, maybe in countries where there are a lot of, I don't know, treasure troves or other stuff that forces or facilitates or induces the government to have a strict enforcement of law, maybe. But so I would say, in summary, I wouldn't brush aside cultural explanation, but as an empiricist, I would like to see more accurate or actionable way to study culture instead of just claiming culture matters, but didn't kind of show how culture matters to begin with. And like in all empirical analysis, machine learning or not, you rarely would see an algorithm that would perfectly predict or perfectly classify legal rules into certain families or into some other, for other purposes. You could say there's always the residuals or the errors that could be explained by culture. And I look forward to see research that could kind of fill the gap. And for your information, there's a paper in Oxford Journal of Legal Studies by, I think at 2020 or so, by Giuseppe Mattiacci. He was at Columbia Law School, now back to Amsterdam Law School. He used whether a language in a country that use cultural pronoun drops or other like gender aspect of the language to explain the adverse possession law and goods faith purchase law in the country. So that's kind of a quantitative attempt of something linguistically or culturally idiosyncratic to a country and correlate that with the legal doctrine.
Simon?
Yeah, so yeah, again, fascinating, sorry for the construction, fascinating talk. So my question actually stems from the fact that the law science community, can you hear me well? The law science community comes from a very, very diverse, everyone has a very diverse background on different methodologies, and you yourself has employed different methodologies within, all of your work. So it's just a broader concept of, maybe can you share a little bit more about when did you decide that machine learning is necessary for you to conduct research? How did you justify this choice, and how would you advise people with a very different kind of background to kind of enter this right away? How would students start in this regard?
Yeah, that's a very good question. So the question is, when should the dog wax the tail, and when should the tail wax the dog? You would see in economics, sometimes it's the tails that wax the dog. They have very powerful tools. Now the trend in economics is to do causal inference. So scholars are attracted to do research only when they can do causal inference, even though the topic may not be important. So throughout my career, I've always picked legally important topic, or at least I think it's legally important topic, and then see which method the topic requires. So that would explain why in some of my work, I have qualitative interviews. In some of my work, I have experiments. In some of my work, I have machine learning. Some of my work just traditional regressions. Some of them just descriptive statistics. Some of them have causal inference. But they all tie to, I think, important questions. So like here, 10 years ago, when I started it, the research questions is really straightforward. So everyone, at least everyone in economics and everyone in World Bank and IMF bought the LSV classification. But then even with legal training, I don't think I could kind of rebut LSV's classification at an abstract level. So I think, okay, I have empirical training. I like property law. Maybe I should compile a data set. Like only after 10 years would I know that it is a very labor-intensive project. And many of the people, well, some of the people now at the Zoom were my former IA helping with this. This is very time consuming. But then after you have this data set in your hand, you ask yourself, so what now? How can I classify countries into legal families? So a traditional approach would be to say, okay, I can cherry pick a few dimensions. Maybe I think adverse possession is the most important. Maybe I think finders keepers is the most important. But then why don't I use the entire data set? But then with 270 dimensions in 156 jurisdictions, like what traditional legal tool would enable me to use this as a whole and to come up with a classification? And the answer is no, okay? So I look around and I think, okay, unsupervised learning is the most sensible tool to have a stable, replicable way of using all the hard plain-coded data set into one result. So that's what I said, the dog wags the tail. I have this research question, I compile the data, and then unsupervised learning is the most appropriate way to use them, and that's why I use them.
Hi, Ping.
Hi, can
Hello.
you hear me?
Yes.
Hi. Yeah. Nice to meet you. And I mean, nice to see you again. And thank you so much for your talking. May I ask a very trivial question? Like, can you show me the slide with the different color points?
You mean
Like, here, this, exactly. Yeah. So I have a really like interpretation question. So when there, like, for example, like when the 2 points, like one point is labeled as an orange and the other is labeled as blue, but somehow, like some orange points, it seems like they are even farther.
Yeah.
I mean, yeah. So I don't know how to explain that when the orange, why a point can be labeled as orange, but actually it is even closer to like blue.
Okay. Yeah. So I was very quick going through the slides. So because there are so many different types of machine learning methods, so you wouldn't want to rely on a single algorithm for presenting your results, because referees will ask about it, and at conference people ask about it, and there's hardly any reason to justify using one. So we use a number of them. So here, t-SNE, if you just run t-SNE as a dimension reduction algorithm, it will just give you the dot and the country name without the color.
Okay.
The colors come from hierarchical clustering, and I divide countries into 10 groups. So I use the color here on the t-SNE plot so that you could see whether hierarchical clustering and t-SNE come to the same conclusion. So here you can see the orange group come from clustering, kind of scattered on the plot, sometimes beyond the red groups and the gray group. So that means t-SNE and hierarchical clustering don't always agree. But then you look around, you see, okay, the gray dots kind of cluster together, the black dot kind of cluster together, while Vietnam kind of intrude into the black dot. And then you see the purple dots are the 4 Nordic countries other than Iceland. So you can see there is a nice consistency between the two, but not perfect consistency. And with t-SNE, because I run it the next day, they will look slightly different. So you can never say there's perfect consistency. But given that they are consistent to a large extent, and no matter you look at t-SNE or look at clustering or look at UMAP, you find results that are different from Schweiger and Kress, different from LSV, then you have a stronger argument to make that the prior literature, at least in terms of property classification, wasn't kind of borne out by the data.
Okay, thank you so much.
Sebastian?
Hello, Professor. Thank you so much for your presentation. I think it was amazing, extremely interesting. I have no knowledge on this field, so just another trivial question for the people that are lawyers that are not so expert in the field. So it's a very time-consuming process to enter the data, right? So in your opinion, like right now, there's no like enough databases that we could access, or maybe any like AI's machine learning or whatever technology to gather the data and input and put the data together, instead of like spending like 10 years gathering the information if I want to create a database on which to work?
Okay, let me start with a story, like this is relevant. And maybe some of you are from UVA, and maybe some of you have read the work by Mila Versteeg. So she and I were kind of same cohort. And I know her when she was a PhD student at Oxford. She spent a year in the library of Oxford reading every country's constitution to compile a data set. And she used that data set for her dissertation and her for first few publication. So that landed her a job at University of Virginia Law School, very top law school. And from a PhD at Oxford straight to the top 10 law school as an assistant professor was like kind of unheard of. But the efforts, the knowledge, and the result that she can produce explain perfectly the landing. So I want just to say, I also spent like 10 years doing this, but I expect that this would be kind of my signature work for years to come. But I think the question is always whether you should do this at the doctoral student stage. So the Miller-Stick story is, yes, you could do such an investment if there's a funding, and it would help you land a better job because your dissertation was more expensive. But then if you're risk averse, you could always wait until you're tenured or have a tenure track job to do this. And you ask about whether there are other methods to gather data. So I didn't tell you about text mining today. So text mining would be, you can feed original raw documents into the machine, and the machine will tell you how to classify the Constitution. You could read David Law, also a professor at UVA, his paper I call Constitutional Archetypes at Texas Law Review, I think 2019 or 2018. He fed the preface of each constitution into a text mining algorithm, and a text mining algorithm based on those declarations would classify countries into 3 big types. So that's like one way to do this. So if you follow this text mining approach, you do not have to hand code data, but you have to gather a corpus of document that is like maybe the population of your research. For example, all the Constitution's preface, then you feed them into it. Or you could read another paper by Julian Nurko and others at Cornell Law Review, also around 2018. So the research was about feeding the US congressional minutes since the 19th century to 21st century. I think like more than 100 years, every congressman's speaking into the machine, because congressional minutes have been recorded in a consistent way. Would say like Kennedy, Democrat, Massachusetts. So it's very easy to know who speaks what. And then they could use the like text learning technique. For example, they could say, when congressman talks about the US Constitution, which clauses, which articles are they talking about? And they find things that human beings could not possibly find because no one has the time to read 200 years of congressional records. Okay, so they find, okay, at a certain point in time, people talks about slavery before the Civil War. At a certain point in time, like the jury, like right to jury has been kind of hotly debated. Okay, so they don't have to call the entire corpus, though in their case, I think they still coded a small portion of it to make sure the algorithm could be finely tuned. So that is kind of 2 approach. My approach is to use human intelligence to convert text, like civil codes, into numbers, and then that the algorithm take over. And some people would want to do the text mining thing, like constitutional law, because each constitution has an English translation deposited in the UN Secretariat, so one can use it. But in my case, some of my civil codes are in Turkish, in Indonesian, in English, in French, in German. So I cannot, there is so far no text mining algorithm that could digest documents in different language now, but I'm sure it will one day, but not now. Hopefully that's a kind of broad enough answer to your question.
I'm sorry, Kaijin. Unfortunately, we're running out of time, so we should spend like 30 seconds for Simon to take a picture of us.
Well, thank you very much, Professor, for the talk. Can you stop sharing your screen and let's take a picture for social media and just, you know, do take to make sure that you can leave something behind here. All right, so fantastic. Please turn on your screen. Oh yeah, turn on the screen and let's take a picture together, Marilyn. Okay, I think Marilyn is not in front of her computer, but all right, 1, 2, 3. Thank you. And let's take another one. All right, 1, 2, 3. Thank you. Back to you, Patrick.
Okay, thank you very much for today's event, and thank you, Professor Chang. Very fascinating talk, and we will see you in our next academic year, I think. Bye-bye.
Thank you very much. Thank you. See you.